Sorry, I did. Yep, Riley.
Thank you, Madam Chair, members of the committee. Riley Scott on behalf of WACO, requesting the Pittsburgh Port Authority tax credit extension, reauthorization, I should say. It's RS 2486.
Okay, are there any questions? Any objection? Seeing none, and I will let the committee know Riley did approach me in advance so that we don't just have people popping up out of the audience. There is a process. So thank you, Riley. Okay. We'll make that request. We'll begin with the presentation now.
Good morning again, Madam Chair, members of the committee. My presentation this morning is on Kansas constitutional requirements and the property tax. You have in front of you today is a handout that is kind of a brief, very brief outline of some specific provisions found in the Constitution, as well as some case law citations that you can follow along a little bit. Today's presentation is a general overview of some Kansas constitutional requirements and authority that specifically relates to property tax. It's intended as a general overview of the more specific provisions of the Constitution that touch on property tax. And we're not going to go over in my limited time, and this is a very complex area of the law, we're not going to go into more general constitutional issues like unlawful delegation or due process. We're not going to go over those. We're going to touch on the things that actually specifically cite property tax. Most of the provisions I will talk about today are found in Article 11 of the Kansas Constitution. It is titled Finance and Taxation. And if you, the first couple pages of your memo from me today is the outline, and then attached on the back are a couple pages of Article 11, because I didn't want to type out the entire thing for you in my memorandum. I'm sure you don't want to see that, but I will refer you to a couple things in there when we get to those provisions. The memo itself is broken up into a couple different areas. What you will see outlined is system of taxation, which relates to both valuation and classification, as well as object of the tax and exemptions. At the very end of the memo, you'll also see there's a couple citations. We may not get there today based on our limited time, but there is constitutional authority provided for the 2 permanent state tax levies for the state building funds, and I've got those citations for you there as well. So to begin, Section 1 of Article 11 governs property tax and provides a framework with multiple purposes. Section 1 addresses valuation, rate of taxation, classification, and exemptions. And my first topic today is the requirement of uniformity and equality, which last session we touched on that. I think over the summer with the interim, we also touched on that a little bit. But if you will see in subsection A of Section 1, you will see a statement in the Constitution that provides in part that except as otherwise hereinafter specifically provided, the legislature shall provide for a uniform and equal basis of valuation and rate of taxation of all property subject to taxation. In Kansas, to satisfy this constitutional requirement, the legislature has statutorily provided that all taxable property shall be listed and valued annually as of January 1 at its fair market value. So fair market value is the standard that is used for most of the properties. except for those properties that are constitutionally accepted. And we will touch on that here in a minute because there are a few constitutional exceptions to that rule. Some examples of statutes that address some of these uniform and equal provisions. You can find, I've listed some on page 2 of your outline. We've already gone over that. And one of the ones I want to touch on is the definition of fair market value that you will find in the statutes. It is in KSA 79503A. Fair market value is defined as the amount in terms of money that a well-informed buyer is justified in paying and a well-informed seller is justified in accepting for property in an open and competitive market, assuming that the parties are acting without undue compulsion. And then further in that statute, you'll also find a list of factors. It's a non-exclusive list, but a list of factors that appraisers would consider when determining fair market value. So fair market value is the standard that has been adopted to comply with the uniform and equal provision of the Constitution. There are some constitutional exceptions that have some other valuation methodologies. One is land devoted to agricultural use. Another is commercial and industrial machinery and equipment. And then some motor vehicles are accepted out of there as well. You will see, if you look at the attachment, the first page of the attachment, which is section 1 of Article 11, you'll see some statements there that the legislature may provide for the classification and taxation uniformly as to class of recreational vehicles and watercraft as defined by the legislature, or may exempt such class from property taxation. You'll see that the provisions of the subsection shall not be applicable to the taxation of some motor vehicles, mineral products, money, mortgages, notes. And so there are some other exceptions that can be found in the Constitution. The only real property exception that we find there is land devoted to agricultural use. And as you know, within the constitutional classification scheme, that is a classification. And there is a provision in the Constitution. If you look at Article 11, but it's Section 12, it also provides that land devoted to agricultural use may be defined by law and valued for ad valorem tax purposes upon the basis of its agricultural income or agricultural productivity, actual or potential. So that is another provision that is found in the Constitution. The basis, as I said, the basis that the legislature has selected is fair market value. So when we are looking at uniformity and equality and fair market value, when evaluating new statutory language addressing the valuation of property, the question that we usually are asking ourselves is whether that provision allows the property to be valued at fair market value. And the proper test for determining whether a valuation statute conforms with the constitutional mandate is to determine whether the special treatment given to the valuation of one group of property bears a reasonable relationship to the actual fair market value of the property. So kind of looking at page 2, so we've looked at valuation, we're looking at uniformity and equality in valuation. The Constitution also provides a list of classifications. And the classifications are essentially classifying real property and personal property. And then they provide assessment rates, or the rate at which the value will be taxed. So class 1 is real property, class 2 is tangible personal property. And the memo itself does not have those classifications set out, but if you look at the attachment, I have attached, there's a page 120 from our constitutional volume that shows you the 7 subclasses for real property and the 6 subclasses for personal property. One of the ones that you've Seen recently come up is residential. You'll see Class 1, subsection 1, real property used for residential purposes is assessed at 11.5%. And if you go to personal property, you will see also there that mobile homes used for residential purposes are also assessed at 11.5%. And if you recall how that works, you have just as an example, if your home is valued at $100,000, its fair market value, and it's classified as residential property, you would multiply that $100,000 by 11.5% to arrive at your assessed value, which would then be $11,500, which is then the number that is used when calculating your tax bill. The mill levy is applied against that assessed value. So just as a brief example, that's how that works. Again, kind of if you think about it though, those classifications in and of themselves are a constitutional exception to our uniform and equal rule. Because if it were truly uniform and equal, it would all be 100%. So this is, again, a constitutional exception to uniform and equal. And just a little from a historical perspective, the classifications that you see, the concept of different classifications with different assessment rates was first added to the Constitution by an election in 1986 that the provision actually took effect January 1 of 1989. So if any of you recall, that time period was called reappraisal. And so that's when the classifications and those different assessment rates first went into the Kansas Constitution. It was not identical to what you see today because those classifications were modified slightly. There were some additional ones that were added by an election in 1992 that took effect in 1993. So, but just from a historical perspective, those classifications have not always been in our Constitution. The next topic that sometimes we don't hear a lot about, but I want to point out, is object of the tax. This is found in Section 5 of Article 11, and the provision actually provides that no tax shall be levied except in pursuance of a law, which shall distinctly state the object of the same, to which object only such tax shall be applied. And our courts have found that this particular provision is applicable to property taxes, not excise taxes. And then in addition, we've had some case law that has found that this particular provision does not preclude a tax levy statute from having more than one object, so long as the legislature does provide a formula or methodology for the allocation of how those how the objects described in the levy will be applied. Page 3, we're going to now turn to, of my memo, we're going to turn to exemptions. So we've talked a little bit about valuation, we've talked about classification, and now we're going to talk about exemptions. Article 11, Section 1, subsection B has a list of what we kind of refer to as constitutional exemptions. And it provides that all property used exclusively for state, county, municipal, literary, educational, scientific, religious, benevolent, and charitable purposes, farm machinery and equipment, merchants and manufacturers' inventories, other than public utility inventories, livestock and all household goods and personal effects not used for the production of income shall be exempt from property taxation. So we do have a constitutional exemption or constitutional exemptions. In Kansas, we also have statutory exemptions. It has been found that our Constitution does not prohibit the legislature from making additional exemptions, and so therefore the legislature does have that ability. There are some concepts, though, that still apply when the legislature is making statutory exemptions. The first is that the authority of the legislature to provide additional exemptions, that those exemptions need to have a public purpose and promote the general welfare. In addition, Courts have found that there's actually 4 key elements when a statutory exemption is being reviewed for its constitutionality. And the elements that are to be considered is whether the exemption furthers the public welfare, whether the exemption provides a substantial peculiar benefit, whether the exemption provides for large accumulations of tax-exempt property, and whether the exemption is an improper or preferential classification of property. And there are a myriad of court cases out there that address different statutory exemptions over the course of time, over 100 years. I mean, there's many different cases out there. One that I chose here to provide to you is the Topeka Cemetery Association case, where the court found that a tax exemption when private property is involved, so not a governmental exemption, but a private property exemption is involved, the tax exemption must be based upon the use of the property and not on the basis of ownership alone. The reason for the rule is that the classification of private property for tax purposes based solely upon ownership unlawfully discriminates against one citizen in favor of another and therefore is a denial of equal protection of the law. And for your information, if you're interested in looking at statutory exemptions, I would say many, if not most, of our statutory exemptions in Kansas can be found in Chapter 79, Article 2. But there are some sprinkled about in other chapters. So if you're ever looking for something, let me know and we'll see what we can find. The last item I want to touch on today, just because this is a constitutional provision that relates to property tax. It's not what I would consider a requirement per se, as we've been talking about uniform and equal and exemption requirements. But when we are looking at the Kansas Educational Building Fund and the State Institutions Building Fund that many of you are aware, there's a 1 mil levy and a half mil levy for those building funds. The Constitution actually does provide the authority for those permanent tax levies until the legislature decides to change it. And so the citation to Article 6 and Article 7 is there if you're interested in taking a look at those. And with that, I'd be happy to stand for any questions you may have today.
Amelia, that was great information. Committee, any questions? And it's going to be very useful going forward for this committee. Senator Erickson.
Thank you, Madam Chair. Thank you so much, Amelia. Very helpful. On page 2 at the top, when the proper test for determining whether evaluation, that statement, how is the special treatment given to the valuation of one group, how is the reasonable relationship determined and by whom?
I think there's I think at the beginning, at the point when statutes are being considered and drafted by the legislature, by legislators, and are being proposed, I think that it is something that needs to be considered. Is the statute that's being proposed, the bill that's being proposed, is the methodology or the factors or something that is in that bill, is it related to the current fair market value standard, and something related to the property itself versus the person who may own or operate that property. And that was the issue in that particular case, was that the statute at issue in that case was challenged because the argument was that in certain circumstances, certain property was not going to be able to be valued at fair market value. It was going to be something less than fair market value. And the court found that's not an appropriate methodology within the statutes. So I think at the beginning, it's the legislature who should be thinking about those things and revisers thinking about those things. But ultimately, if a statute is challenged, it would be the courts who would actually make the final determination of whether it's constitutionally compliant or not. But we would, but the assumption is that it's constitutional, and then it would be up to someone to challenge.
Thank you. Thank you, Madam Chair.
Thank you. Any other questions, committee? Seeing none, thank you, Amelia. Our next presentation is by Eddie Penner.
Thank you, Madam Chair and members of the committee. I am going to do an overview presentation of the local ad valorem tax reduction fund, certainly related to property taxes. And this is designed to hopefully be of assistance for tomorrow's hearing. You're hearing a bill tomorrow on this topic. That bill, if you actually look at the text of it, it's difficult to tell exactly what it does. It just makes it clear that transfers would begin, since it's a bill from last year. The transfers would it has them starting in 2024, obviously, in the event of an infinitely regressing in size presentation. You may not be able to see that, but the transfers beginning in 24. Obviously, if you work that bill, you may want to consider updating it for the new session. But the statute just reads as that they would begin at that point in time. And so I'm going to try sharing again and see what happens. So this is the bill, but this is designed to hopefully provide sufficient information to where the language of that statute, being so limited in terms of what would actually happen, isn't an obstacle for you as you are considering it, and hopefully will enable you to focus tomorrow on the actual merits or demerits of the proposal and not be worried too much about the operation and the mechanics of the program. And so I'll talk a little bit about the history of it, and then talk about how the transfer amounts are determined, how those transfer amounts are then distributed to the locals, how they're then distributed within the locals, and then finally the statutory provisions for the utilization of those funds. And so as a matter of history, this statute as it currently exists was originally enacted in 1965. It has been amended 39 times since then. There are a few years where it was amended multiple times within those years. And then obviously for the last about 20 years, there has been an annual or biannual amendment to the statute where the legislature strikes out and replaces the previous fiscal years, because for about the last 20 years, the transfers have been suspended. And they are typically suspended on a 1, 2, or 3-year basis. And so the habit of the legislature has been at the end of that time period to remove the older years that are now outdated and provide that the transfer should be suspended for the future years. However, while I say that this statute was enacted in 1965, that statute was actually just a recodification of the existing sales tax statutes that existed then. And the idea of taking some fraction of sales tax revenue and distributing it to the local governments in some form or fashion dates all the way back to the inception of the sales tax, which was in 1937. If you look at that 1937 sales tax statute, actually none of the sales tax revenue went to the state general fund. It went to the state sales tax fund, which was an appropriated special revenue fund. And basically the way it worked is at the end of the year, whatever kind of residual monies there were remaining in the fund that had been receipted by the state but had not been spent through those appropriations, I believe it was 80% of those unspent sales tax dollars were then sent out to the locals. The other thing you probably ought to keep in mind is that in 1937, we had total revenue limits for locals under their property tax authority. And as a part of that distribution of local revenue, their property tax revenue limitation was reduced by I believe it was 80% of whatever they received in the form of sales tax revenue sent out to them. And so it's in its earliest incarnation, this sharing of sales tax receipts to the locals was designed purely and directly for property tax relief and was statutorily structured as such. The other kind of high point that I would note there is that in 1937 there was no local sales tax authority, and so the idea of sharing state sales tax receipts was somewhat designed to make the only sales tax in the state sales tax, both a state and local revenue source. In terms of the maybe key information for tomorrow's hearing, in 2003, when the the receipt impacts from the early 2000s recession were really starting to come into full effect for the legislature during a rescission or supplemental appropriations bill early in the session. The legislature eliminated the second of the two transfers from that fund, which was in essence the January transfer, and then legislation later in that same session suspended all the transfers of that fund for fiscal year 2004. And it's been since that point in time that no money has gone into the transfer. So from there, I'm happy to field questions as we go or wait to the end.
Sure. Let's go ahead and take them. If we run over, we'll just continue another. Senator Holland.
Thank you, Madam Chair, and I'll be brief, Eddie. This is a great presentation. So 2003 was the first year I was actually in the legislature or in the House. When this went through, I remember the recession we had that was going on and how it was affecting particularly South Central. My question is this: what was the legislature's reason? Was that basically to be sure we had dollars in the state general fund to fund schools and other things like that? Is there any institutional wisdom or knowledge about what was pulling that back?
So I believe, so the first suspension of that second half of fiscal 2003 was certainly that. That was done in an early session bill where there was a concern of whether or not we had enough money in the SGF to get to the end of the fiscal year. Now, in terms of the beginning for 04, the kind of indefinite suspension of the transfers, at that point, it was probably more of just a wholesale budget balancing mechanism, not necessarily do we have dollars in the bank. So at that point, it kind of became a more straightforward, ongoing fiscal policy decision of the state that this wasn't what we were going to do with the money.
Okay, thank you. Thank you.
Mm-hmm. And so the way the transfer amount is determined is, it's kind of interesting to read it, is that there is a base transfer amount written into the statute, and that is 3.63% of the state general fund portion of sales and use tax receipts from the preceding calendar year is distributed on January 15th and then July 15th, which means that's actually split across two different fiscal years, because the fiscal year begins, of course, July 1. The statute currently reads that there are to be no transfers at all in fiscal years 23, 24, and 25. And then in fiscal year 26 and all years thereafter, the transfer amounts are to be $27 million each of those times. And so the way the statute currently reads is that 3.63% provision is in there, but then we have later down in the same section that it doesn't matter, basically. However, I thought since tomorrow's hearing does include the elimination of that artificial amount of 27 million and a return to the 3.63%, I thought it might be beneficial for you all to have information regarding how much those transfers would be in each of those fiscal years if the base amount had been enacted. And so you can see that it starts, fiscal year 19 is as far back as I reached for putting here, just because that's about what I had space for. It would have been 99.5 million. You can see that would have grown to where the transfer amounts in fiscal year 24 would have combined to 130.5 million if the law had been in place going forward. And I obviously couldn't have determined that fiscal year 24 amount until January 1 of calendar year 24, because the January transfer for 2024 is based upon actual receipts for calendar year 2023.
And if I may, Eddie, the governor in her budget the last couple years, when she chose to fund the LAVTR, she chose the limited version, the 54 million, not the 3.6%.
That's my recollection that the last 2 years. Yeah.
I just want the committee to be aware of it, that there's two numbers out there. It does get confusing, but the governor's budget did include the 54 million, not the increased.
Not the formulaic number.
Thank you.
Yeah, but the bill you're hearing tomorrow does have the formulaic number back into effect. And so from then it's a question of
Senator Peck.
Thank you, Madam Chairman. For clarification, on your one slide, it says 3.63% of SGF sales. So sales tax money comes in, a portion is automatically, if you will, goes to the state highway fund. So that portion does not count as a part of the 3.63. It's only the rest of the sales tax.
Yes, that's correct. The highway fund doesn't doesn't have any fraction of it getting transferred to the local ad valorem tax reduction fund. It's just the SGF fraction.
Even though it is sales tax revenue, it goes directly to the state highway fund. Are there any other designated places that
There are.
sales tax revenue goes directly, like to the state highway fund, that do not count in the 3.63?
Yes.
As a matter of the application of the tax, yes, and then there's actually a very small amount of it that goes to the State Fair Capital Improvements Fund, and that's for sales that take place on the state fairgrounds themselves. And then also, almost just the way the tax is administered, there's a refund fund that the Department of Revenue keeps sufficient monies in to pay the legally entitled refunds of the sales tax, but that's not, that in effect, that comes out as a wash over time, because those really aren't sales tax receipts if they're refunds that go out, so. But that state fair portion is also separate, and it's geographically determined, not percent-based determined. So then you're probably wondering what happens to this money once it's put into the fund. It is distributed across the state on a countywide basis using a two-factor formula. The first factor is 65% of it is based upon that county's share of the statewide total population. And the second factor is 35% based on that county's share of the statewide taxable value. And so I've also included in your materials, you should have a handout. It's a two-page document. It lists all 105 counties and then a bunch of numbers. Those numbers are in essence what the counties would get. And this is a document that the Property Valuation Division of the Department of Revenue maintains, even though we haven't transferred any of the money into this fund and sent it out to the locals now in about 20 years. They do keep this up to date because they're almost on a somewhat annual basis. There is, of course, legislation that would consider this. And even if there's not actually legislation, there are legislative requests to consider this, and we get asked for this document. And so this shows each county's assessed valuation, each county's population, and then the third column is the fraction of the statewide total LAVTRF that they would receive. And so you can see there at the very top of the first page of that document, you can see that Allen County would receive 0.4% of the statewide LAVTRF. Dropping down to counties where it's easier to maybe read the numbers, you can see that Cowley and Crawford, both alphabetically sequential and somewhat similar sized counties, would receive both slightly more than 1% of it. If you drop down just because these probably an inevitable question if I don't point it out, you can see that Johnson County there would receive about 24.5% of the total. Flipping this over on the backside, you can see that Sedgwick County would receive about 16.3% of the total. The other columns show under a hypothetical LAVTRF distribution of $54 million, how many dollars that county would get. Obviously, tomorrow's bill isn't that dollar amount, but this is what I had available. And then the last three columns are the hypothetical property tax relief in those counties. How much of a mill levy the total reduction in the county would be if all of this money was used to reduce the mill levy, and then how many dollars the hypothetical taxpayers would benefit by that if they had a $150,000 house or a $500,000 commercial piece of property or a piece of agricultural land whose use value was $50,000. And so the next slide that I have is then once it goes to the counties, what happens to it? The statute provides for it to be distributed within the counties based upon the pro rata share of the amount of tax levied within the county. School districts are excluded, and there's actually one other exclusion for municipalities located entirely within the Fort Riley Military Reservation. But I've got here a hypothetical example, small county, and I did kind of take these based upon an actual very small, very rural county that exists. You can see that this is kind of about what their property tax amounts are in that county. The state, $80,000 of property tax, the county, 6.8 million. The school districts in the county combined to about 15.6 million, working your way down there. And then you can see what the LAVTRF distribution would be. Since this is the hypothetical that I have here is a very small rural county, they don't have a lot of local governments other than their county government. And so this, I do want to make it clear that while this shows that 40.9 million of the $45 million allocation would go, or the 45,000, excuse me, allocation would go to the county government, In some ways, this is non-representative because the smallest, most rural counties, oftentimes the county government is by far the vast majority of the governmental entities within the county. If this was a more urban county or a more populous county, it would be more widely distributed. I had to kind of balance the simplicity of the example with whether or not it was in fact a representative example for this purpose. And so the main thing here that I do want to highlight, though, is that the state does not receive any of this LAVTRF back to the state. It doesn't serve to reduce the state's 1.5 mils that it levies. And also school districts also are carved out of the LAVTRF. That is, school district mill levies are set a little bit differently than other mill levies. I mean, in some ways they're the same, but in some ways they're different. Obviously, the 20 mills is set totally different than every other mill levy in the state, but also the other school district levies are formulaically determined and statutorily provided for in a fashion that differs from city and county mill levies. And so then the other thing that I want to highlight is, so what happens with these funds? And there are some limited provisions within the statute of what happened to. They have to go into a fund that has a tax levy in the local government's budget. So if a local government has multiple funds and some of them don't have property tax levy, they can't put LAVTRF funds in those funds. They also can't go into bond and interest funds. The state, by virtue of the LAVTRF, is not getting in the business of paying capital debt of local governments. And then finally, the budget as it adopts has to show that the LAVTRF distribution and the sum of the property tax levied by that fund cannot exceed the maximum amount of that fund. That's somewhat of a archaic provision because it dates to a time when we did have individual fund levy limits and aggregate fund levy limits. And the point of it was that this you can't use the LAVTRF to exceed those limits. The reason I say that's somewhat of a historical archaic factors. Now we typically don't have those, and to the extent that we do, they're by and large concentrated in the school districts, which don't receive LAVTRF money. And so that's the extent of what I had planned to share with you all. Hopefully, just some helpful background information in anticipation of tomorrow's hearing. And I would happily stand for whatever questions.
Thank you, Eddie. It's great information. Committee, any questions? Senator Holland.
Thank you, Madam Chair. And I don't know if you want to say these questions for them all for the hearing, or what do you want to do? Because I just.
This isn't a hearing. This is, yeah, I wanted you to be prepared for tomorrow. If you have questions on this information, then it's pertinent today. Yes, thank you, Senator Holland.
Thank you, Madam Chair. So Eddie, what I'm looking at here is that, so we have the hypothetical property tax release for the real residential, commercial real, and then the ag land use value. Were you able to draw any correlations between level of non-taxable personal property by county and basically seeing any trends there, either correlations between, yes, we can definitely tease out the fact that certain counties, if they do have, say, more federal buildings or more, say, state property, that we do see they do receive additional benefits over this. I wonder if any analysis has been done on that. And the second thing I would have is that, I mean, we have these residential property, I mean, $130,000 property in, rural Kansas is a whole lot different than some other county. And I guess my question is that I would find this a lot more meaningful if you basically had for each county what your average real residential property value and what that really translates to. So I just trying to tease out some additional, I mean, this is great data. I'm glad we're having this discussion today. Thank you, Madam Chair. And thank you.
So with regards to the first question, if a county has more exempt property, they actually would, in essence, receive less LAVTRF because of the fact that the amount of taxable value in their county is one of the two factors in determining what their LAVTRF ratio is. And so the greater they're exempt, the less of their property is taxable, resulting in them getting less LAVTRF money. In terms of that second question, yeah, I can certainly ask the Department of Revenue to give me the countywide average residential value and plug that in there.
Thank you.
Mm-hmm.
Thank you. Committee, any other questions? Just for clarification, this is on real property vehicles, or would this be a decrease if the money was out there, the residential, your adjusted mill levy equivalency.
So those mill levies would apply to anything to which the mill levy applies. So anything taxed on an ad valorem basis. And then obviously to the extent the mill levy is reduced, the following year, the average countywide mill levy would also be reduced. And so that would flow through to the vehicle tax.
Okay,
on a
that's what I wanted
one-year
to make
lag.
sure. And personal property too.
Well, taxable
Personal
personal
separate,
property would be taxed in the
Right.
current year the same way the real estate is.
Okay, great. Committee, Senator Reddy.
Thank you, Madam Chair. When it says mill levy equivalent reduction, there isn't any caveat that says anything like, if you receive this money, you need to reduce your mill levy. We're just making that assumption that this is what it would equate to.
Yeah, that's exactly right, and that's a good point. This assumes that every dollar of this $54 million LAVTRF goes directly to nothing but reducing the mill levies uniformly.
If they were to do that.
Right.
It's a decision on locals.
Yes.
Thank you.
Committee, any other questions? Thank you, Eddie. Our next presentation is Andy. Andy, Brienzo, I apologize. I just know you as Andy, so
That's fair.
Brienzo. Well,
Thank you,
Thank
Madam
you.
Chair. Members of the committee, I see we have about 10 minutes. Should I do this in 5 minutes or less? Okay.
and I think you can because it's all documented and the committee can refer back to it. But I wanted them to be aware of it because we do base our decisions on these fiscal notes many times. It's important that they realize that the committee understand the results of this audit. Thank you.
Okay. Well, thank you,
Although I
Madam
think
Chair.
everybody knows in the back of their mind what you're going to say. But thank you.
So this audit was requested by Senator Alley. We just presented it at the LPAC last month, so some of you have very recently heard this. But the question we're answering here is, do agencies provide accurate and reasonable estimates in fiscal notes for potential legislation? Now, if you flip with me to page 4, I'm flipping through the paper report. The PDF should be the same. Changes made to bills, this is the bottom line answer. Changes made to bills after the fiscal notes were submitted resulted in most of the inaccuracies that we saw, but a few fiscal notes were unreasonable because of agencies' methods. So pages 4, 5, 6, and 7 have background information about fiscal notes. I won't belabor that part because you all know what they are and what purpose they serve. I do want to make a couple of high-level points, though, to keep in mind as we go forward. The first is that although the division of the budget creates fiscal notes, the data that they're using, the actual fiscal estimates that are in there come from the agencies that will be affected by the legislation. The second is that when the division of the budget, you can see this at the bottom of page 5, gets those fiscal estimates from agencies, they do a high-level reasonableness check. They're processing on a pretty quick turnaround, about 600 of these every session. And so they just don't have the staff to do anything more than a high-level reasonableness check. Now let's turn to 6 and 7. This is a critical point, which is that statute only requires fiscal notes when bills are introduced, so for original legislation, doesn't require updates when bills are amended. So there's no new fiscal note or updated fiscal note that reflects the amended bill. The original fiscal note carries on with the bill, even if the amendment has changed the bill significantly. Okay, now getting into the work that we did to evaluate the accuracy and reasonableness of fiscal notes, let's go to the bottom of page 7. We did 2 main bodies of work. On the one hand, to determine accuracy, we reviewed 10 enacted bills from the 18-19 sessions. We compared the estimated fiscal effects that were in their fiscal notes to their actual fiscal effects after they took effect to see how well they aligned. To determine reasonableness, we selected 10 bills that died from the 21-22 sessions, so that's a little bit more recent to get a handle on what agencies are doing now rather than in 18-19, let's say. And we reviewed whether agencies followed reasonable processes that were based on the U.S. Government Accountability Office's fiscal estimation best practices. And I will get to the details of those in a minute. Let's start with the accuracy of fiscal notes for bills enacted into law and flip to page 9. So there's more detail in the report about all of this, but figure 2 on page 9 is a good bottom line summary of what we found. So you'll see that of the 10 that we reviewed, and this is comparing estimates to actuals, 3 were reasonably close. So they were either within 20% or a few $1,000s. We counted that as accurate because in all these cases, agencies are trying to predict the future, which is inherently unknowable with precision. So we thought reasonable closeness was worthy of being called accurate. You'll see though in the middle of figure 2 that 4 of the 7 were inaccurate because the bill was amended. So after the bill was introduced and the fiscal note was created, the bill was later amended, and that changed the fiscal effect such that the fiscal note didn't match the actuals. And then you'll see 3 there where either the agency process changed, there was unpredictable participation, that's for a tax credit that the Department of Revenue couldn't accurately predict how many people would be claiming it. And then there was 1 that was inaccurate because of the agency methodology. We thought they did a good job of doing a long range estimate over 20 years, but splitting that into each individual year was necessarily a little bit imprecise. Okay, let's flip to page 13, and we'll talk about the other body of work that we did. So these are the 10 bills that died from the 21 and 22 sessions. Here we're reviewing agency processes to see whether they're following those best practices and whether they're coming up with assumptions that, or estimates that we think are reasonable. You'll see there figure 3, again, this is our summary figure. There's a lot more detail in these pages if you're interested. 7 of the 10 we thought were reasonable. The agencies followed reasonable processes, came up with reasonable estimates. There were 2 you'll see where we thought the agency was using unvalidated data and some poor assumptions. There's details about those in the report. So obviously, again, they're trying to predict the future. There are necessarily some assumptions that need to be baked into their calculations. And in some cases, we thought they weren't well considered or accurate. And then the final one, the 10th of 10 was inaccurate, or unreasonable rather, because budget excluded a large potential cost to the state that the Kansas Insurance Department had made them aware of, and that was simply an oversight. So in none of these cases do we see like a systemic problem, either with the division of the budgets process or with the agency's process. In most cases, especially for those that were actually passed, it's bill amendments that are rendering the fiscal notes inaccurate, as well as a few other things like process changes and unpredictable participation. If you will flip with me to the conclusion, excuse me, you'll see that we found something similar in a 2010 audit that we did. So we did very similar work in 2010. The conclusions were pretty similar. A lot of these types of inaccuracies are simply unavoidable because agencies are trying to predict the future, which is, as I said, inherently unknowable with precision. The biggest change that the legislature could consider making to try to ameliorate some of these issues is simply requiring fiscal notes to be updated when bills are amended. We reviewed a high-level study on all 50 states and whether they're doing this. In 2015, 26 states were. So roughly half do. But even then, there will probably be some level of uncertainty because agencies are, again, trying to predict the future. So with that, I will stand for questions.
Great, thank you, Andy. Would you recommend that we address the process and request updates as the bills are amended? I know we do behind the scenes. We get that information, but it's not available to the public on the website.
So because that's a policy question, I wouldn't recommend that necessarily, although we are seeing that other states, about half of states are doing that, and a lot of the inaccuracies that we saw are simply due to bill amendments and fiscal notes not being updated. Whether that's feasible for budget would be a question for them.
Right, and I have seen political fiscal notes in the past. Nobody now, this person isn't in office anymore, but when I was a freshman, they were schooling the freshmen, and my bill had a $65 million fiscal note. When I visited with them, changed one word of or the fiscal note went to zero. So I'm not saying that still goes on, but we have seen politics played in the past with these fiscal notes too, so. Committee, any questions? Senator Holland.
Just real quick. Thank you, Madam Chair. Thanks for being here, Danny. I guess my question is So you guys don't officially have any recommendations on changes to be made?
Correct.
So does that mean if you don't have a solution, you don't have a problem? I mean, is this a problem?
I think whether this is a problem depends on legislators and whether you all see it as a problem that fiscal notes do not always accurately predict bills' fiscal effects.
Thank you.
Any other questions, committee? Seeing none, thank you, Andy.
You're welcome.
Well, committee, I know we covered a lot of territory. We do have a hearing tomorrow. It will be a lengthy hearing. And we will pick up with Tuesday's agenda next Thursday. I had scheduled 3 days for hearing 2036. I think we should be able to finish it in 2. We'll have the proponents on Tuesday and the opponents on Wednesday, and then we'll fill in with Tuesday's schedule for Thursday. Committee, any questions or business to be brought before the committee? Seeing none, we're adjourned. Thank you.